Now we will be discussing the Delhi administration. The Delhi Municipal Administration, the first act with respect to the municipal government of Delhi was the Delhi Municipal Corporation Act 1957. This act provided for the establishment of a corporation which would be entrusted with the municipal government for the Union Territory of Delhi as it then was. Now, this particular act provided for the establishment of a municipal corporation consisting of councillors who would be appointed by election. Now, this particular act also provided for the functions of the municipal corporation under Chapter 3. Chapter 3 of the Act provides the functions of the Delhi Municipal Corporation, which include making or passing of bylaws with respect to water supply, electric supply, drainage, sewage disposal, taxation, and many other matters. The Delhi Municipal Corporation is also vested with the power to pass regulations in order to conduct its own functioning. Consequent upon enforcement of the Constitution 74th Amendment Act 1992, Part 9A of the Constitution was amended. Hence, the Delhi Municipal Corporation Act 1957 was also amended in order to bring it in conformity with the Part 9A. With respect to New Delhi, which forms only 3% of the area and also has only 3% of the population of Delhi, it was felt that a special provision needs to be incorporated in order to conduct the functioning of the municipal government of New Delhi. Hence, the New Delhi Municipal Council has been formed. The New Delhi Municipal Council exercises jurisdiction over the New Delhi municipal area. The New Delhi Municipal Council comprises of number 1, a chairperson, number 2, 3 members of the Legislative Assembly who are elected from wholly or partly from the New Delhi area. Number 3, there are 5 persons who are appointed in consultation with the central government from amongst the officers of the central government, and finally 2 people who are appointed in consultation with the central government and the chief minister from amongst persons who are lawyers, scientists, engineers, business analysts, or even media persons, artists, for that matter intellectuals also, and any other category of persons as the central government may specify. The New Delhi Municipal Council has been entrusted with the same functions which are in pari materia with the functions of the Delhi Municipal Corporation under the Delhi Municipal Corporation Act 1957. The chairperson of the New Delhi Municipal Council has been provided with certain responsibilities. It is his responsibility to ensure that certain records or other documents that are lying in his possession or filed in his office are produced as and when requisitioned by the council, and also to produce any reports which are requisitioned by the New Delhi Municipal Council from the chairperson with respect to the municipal government of New Delhi. The New Delhi Municipal Corporation Amendment Act 2011 has trifurcated the Delhi Municipal Administration into three parts. Number one, the New Delhi Municipal Corporation, the South Delhi Municipal Corporation, and the East Delhi Municipal Corporation. As far as the constitutional provisions with respect to the National Capital Territory of Delhi are concerned, we have discussed that Article 239 AA provides for the Parliament to by law provide for the Legislative Assembly for the city of Delhi. In keeping with the constitutional requirement, the Parliament has passed the Government of National Capital Territory Act of 1991, which has provided the right to the citizens of Delhi to elect their own representatives who are given the power to make laws with respect to the National Capital Territory of Delhi. Hence, to effectuate the constitutional provisions, the Government of National Capital Territory of Delhi Act 1991 was passed, which provided for the legislature for the National Capital Territory of Delhi. Moreover, the erstwhile Delhi Administration Act 1966, which provided for a Metropolitan Council and an Executive Council, now stands repealed after the passing of the Government of National Capital Territory of Delhi Act 1991. While the Parliament's will is paramount in case of other union territories, but in the case of Delhi, it is the Delhi Legislative Assembly which has the power to legislate for the National Capital Territory of Delhi. However, there are certain matters which have been kept outside the scope and powers of the Legislative Assembly of Delhi. These matters include public order, police, and land. In case of any conflict between a law made by the Legislative Assembly of Delhi and a law made by the Parliament, the latter prevails. However, if the law made by the Legislative Assembly of Delhi has received assent of the President to it, then the same shall prevail over the law made by the Parliament. Therefore, the National Capital Territory of Delhi has been accorded a special status under the Constitution of India. It is interesting to note that ever since the Aam Aadmi Party came to power in Delhi in 2014 and Arvind Kejriwal was appointed as the Chief Minister of Delhi, there has been a constant tussle between the Chief Minister Arvind Kejriwal and the Lieutenant Governor Najib Young. Now, Najib Young and the Kejriwal government have been at loggerheads with respect to a number of issues, whether it is bureaucratic appointments or passing any particular files. There have been numerous issues between the two. There has been a landmark judgment which was passed on November 2nd, 2017, wherein it was a case which was filed by the government of Delhi against the Union of India. In this judgment, the Supreme Court has clarified the position or the relationship between the power scuffle between the Chief Minister, which is the Delhi Legislative Assembly's head, and the Lieutenant Governor on the other hand. The Supreme Court has held that the constitutional scheme is tilted in favor of the Lieutenant Governor, and hence the Lieutenant Governor enjoys primacy under the Constitution of India. This judgment has laid to rest a huge controversy which has been arising since the appointment of Arvind Kejriwal as the Chief Minister of Delhi. Hence, from the foregoing discussion, it transpires that Delhi, being witness to so many numerous kingdoms and various different empires, is placed at a certain pedestal under the Constitution of India. It is the political significance or the historical or cultural importance which make Delhi a special city and hence has been given a special status under the Constitution of India. To summarize, while the Parliament has been given the exclusive power and has been provided with the supreme power to legislate for the other union territories, in case of Delhi, a special democratic setup has been envisaged by the Constitution. The special provisions pertaining to the National Capital Territory of Delhi are envisaged in the Constitution, and there is a special legislative assembly which is appointed for the National Capital Territory of Delhi. In case of any conflict between a law made by the Legislative Assembly of Delhi and a law made by the Parliament, the latter prevails over the former. However, in case the President's assent has been received with respect to the law made by the Legislative Assembly of Delhi, then the same law shall prevail over the law made by the Parliament. Hence, Delhi being the center of a number of successive kingdoms, it is envisaged and is placed at a higher pedestal than any other particular units of the territory of India. And there are special provisions pertaining to the National Capital Territory of Delhi.